this court cannot make law, it can only interpret it and give effect to it. Page 3. Whether a change should be brought into the legislative regime of the SMA is for Parliament to determine, itself a diversity of viewpoints in the polity. The court, in the exercise of the power of judicial review, must be careful not to tread into the legislative domain. It is clarified that this court has not adjudicated upon the validity of any laws other than the SMA, the FMA, the adoption regulations, and the CARA circular. There is an intelligible differentia in using marriage as an indicator to classify couples in the sense that married couples can easily be distinguished from unmarried couples. However, the differentia does not have a rational nexus with the object sought to be achieved by the CARA regulations, which is to ensure that the best interest of the child is protected. Placing a child in a stable family is undoubtedly in pursuance of a child's interest. However, the respondents have not placed any data on the record to support their claim that only married relationships can provide stability.
Regulation 5.3 of CARA regulations cannot be held void. At the same time, the court is of the opinion that CARA and the central government should appropriately consider the realities of de facto families where single individuals are permitted to adopt and thereafter start living in a non-matrimonial relationship. In an unforeseen eventuality, the adopted child in question could face exclusion from the benefits otherwise available to adopted children of married couples. This aspect needs further consideration, for which the court is not the appropriate forum.
A formal associational status or recognition of the association is necessary for the free and unrestricted exercise of the freedom to form intimate associations. Needless to say, there may be reasonable restrictions on this right. However, other than legally valid and binding restrictions, the right to intimate associations must be unrestricted. The freedom to choose a partner and the freedom to enjoy their society, which are essential components of the right to enter into a union, and the freedom of intimate association, would be rendered odious if the relationship were to be discriminated against. For the right to have real meaning, the state must recognize a bouquet of entitlements which flow from an abiding relationship of this kind. A failure to recognize such entitlements would result in systemic discrimination against queer couples. The Solicitor General of India made a statement that a committee chaired by the Cabinet Secretary will be constituted to set out the rights which will be available to queer couples and unions. The committee shall set out the scope of the benefits which accrue to such couples. If a transgender person is in a heterosexual relationship and wishes to marry their partner, and if each of them meets the other requirements set out in the applicable law, such a marriage would be recognized by the laws governing marriage. This is because one party would be the bride or the wife in the marriage, and the other party would be the bridegroom or the husband. The laws governing marriage are framed in the context of a heterosexual relationship. Since a transgender person can be in a heterosexual relationship like a cis male or a cis female, a union between a trans woman and a trans man, or a trans woman and a man, or a trans man and a woman can be registered under the marriage laws. The transgender community consists of inter alia transgender men and transgender women. A transgender man has the right to marry a woman under the laws governing marriage in the country, including personal laws. Similarly, a transgender woman has the right to marry a man. A transgender man and a transgender woman can also marry. Intersex persons who identify as a man or a woman and seek to enter into a heterosexual marriage would also have a right to marry. The union government, state governments, and governments of union territories are directed to 1. Ensure that the queer community is not discriminated against because of their gender identity or sexual orientation. 2. Ensure that there is no discrimination in access to goods and services to the queer community which are available to the public. 3. Take steps to sensitize the public about queer identity, including that it is natural and not a mental disorder. 4. Establish hotline numbers that the queer community can contact when they face harassment and violence in any form. 5. Establish and publicize the availability of safe houses or Garima Grahas in all districts to provide shelter to members of the queer community who are facing violence or discrimination. 6. Ensure that treatments offered by doctors or other persons which aim to change gender identity or sexual orientation are seized with immediate effect. 7. Ensure that intersex children are not forced to undergo operations with regard only to their sex, especially at an age when they are unable to fully comprehend and consent to such operations. 8. Recognize the self-identified gender of all persons, including transgender persons, hijras, and others, with socio-cultural identities in India as male, female, or third gender. No person shall be forced to undergo hormonal therapy or sterilization or any other medical procedure either as a condition or prerequisite to grant legal recognition to their gender identity or otherwise. B. The appropriate government and the Mental Health Care Act must formulate modules covering the mental health of queer persons in their programs under Section 29(1). Programs to reduce suicides and attempted suicides envisaged by Section 29(2) must include provisions which tackle queer identity. C. The following directions are issued to the police machinery. 1. There shall be no harassment of queer couples by summoning them to the police station or visiting their places of residence solely to interrogate them about their gender identity or sexual orientation. 2. They shall not force queer persons to return to their natal families if they do not wish to return to them. 3. When a police complaint is filed by queer persons alleging that their family is restraining their freedom of movement, they shall, on verifying the genuineness of the complaint, ensure that their freedom is not curtailed. 4. When a police complaint is filed apprehending violence from the family for the reason that the complainant is queer or is in a queer relationship, they shall, on verifying the genuineness of the complaint, ensure due protection. And 5. Before registering an FIR against a queer couple or one of the parties in a queer relationship, where the FIR is sought to be registered in relation to their relationship, they shall conduct a preliminary inquiry in terms of Lalita Kumari versus Government of UP to ensure that the complaint discloses a cognizable offence. The police must first determine if the person is an adult. If the person is an adult and is in a consensual relationship with another person of the same or different gender, or has left their natal home of their own volition, the police shall close the complaint after recording a statement to this effect.